Greetings. It is I again, your King Clifford Jefferson, descendant of Godfrey the Fifth Calaban Jew, son of Falk, ruler of Jerusalem, King of the English Third Temple Church, reformed from the English Church of England as a result of the English Reformation that was done through all of de facto monarchs, we had to restore which was gone and lost, now found and restored by way of proclamation, as stated in our last part 3 of Are You Counted Amongst the Census of the English Nationals? We're going to work with the title. We're not sure how we're going to title it, but it's had to do with census of the English Church. So don't hold me to that title yet. I know I said it a couple of different ways, but we'll work on that. But let's get back to the beautiful lesson. As Archbishop said in this last dissent before we close, that it's really about to get intense now. A lot that's produced and presented in regards to substantiating the equitable and justifiable relief for us as the people have not been presented and argued in a lawful forum that would actually give the people a way to be able to utilize that birthright in regards to their political standing and allegiance to somebody who actually care about them. All right, so, and we're going to show that by way of the Religion Act of 1580. And we're going to show you as a result of what was done in the 4th century under the Gregorian Reformation with the Christianization of the Anglo-Saxon Berbers, whose history has always been English nationals, and our custom has always been paganism because we believe in ourselves. It's very important to understand the aspects of culture, kinfolks, customary, hereditaments, all of these things are paramount in lieu of our faith. And this was actually implemented before these houses or de facto houses even came about. And we know this is the case because, as we said, the national debt that was established by United Colonies, now known as the Federal Union, throughout their dissolutions and restoration under different names. We know that it encompasses the protection of faith for different groups of people known as societies. And we should have the same right as a society. But the Constitution is vague. And it's vague as a result of us not knowing true history. Because the history in the Constitution is meant to be vague until we realize what the vagueness was really about. And this is the result of this act right here called the Religion Act of 1850. So without further ado, let's get started. See, you can start reading.
Religious Act 1580. The Religious Act 1580, Elizabeth 1C1, was Act of Parliament of England during the English Reformation. The act made a high treason to persuade, English subjects to withdraw their allegiance to the Queen or from the Church of England to Rome, or to promise obedience to a foreign authority.
Read that again.
The Religious Act of 1580 was an act of English Parliament during the English Reformation. The act made it high treason to persuade English subjects to withdraw their allegiance from Queen of England to Rome, or to promise obedience to a foreign authority. So,
as we're gonna say, you want to make some insight before I go in?
It's as clear as example. If your allegiance is to England, this is in the 1500s, that means 1492 has already happened. You're 100 years past 1492, so we're still talking about England, and they're not in league with Catholicism, as it were. They're not in league with Rome, as it were, and to be governed, under Roman law in such in conflict with the parliament law at the time. I yield.
Well said, Archbishop.
Yeah, but what it's showing is, once again, anybody who's underneath the Kingdom of England at this time, even though we know Queen Elizabeth and them were also still Roman Catholics, they were just trying to separate themselves from their Roman Catholic side. And based off of how they were trying to do that, they were trying to maintain the English subjects to be able to keep their identity intact via the Religion Act of 1580, because they already knew what was taking place from them coming or trying to come from what they were coming from. And we know that there was nothing more than puppet monarchs since William the Conqueror. William the Conqueror was a puppet monarch from the Roman Catholic Church as well. So we know since 1066, everyone who was sitting on or trying to play as the King of England were also too trying to either A, maintain the English identity, or B, trying to keep the Roman Catholic Church from overtaking the Kingdom of England.
Well said. And as it said, it was the act of the Parliament of England. So the Parliament of England is the government. The act is an act of legislation, because even law that was passed by the House of Stewards, being the monarch, was in violation of legislation passed by the Parliament of England. So just because a law is passed don't mean it's de jure. You know what I'm saying? If it doesn't go based off the government. And the charters that were given by these monarchs, absent of the authority of the Parliament, is ineffective. They don't stand. And as we can see, as a result, it's a violation of the Religion Act as Parliament established. So that means that the House of Stewards, who allowed the colonies to come over here and set up plantations to practice their religious faith, was contrary to this act of 1580, because it created treason. It's an act of treason. And this act went on incited by Elizabeth I, who was the granddaughter or the daughter of Henry VIII, who usurped the crown by way of the breakdown of the Yorks and Lancasters, who were known as the Angevin Plantagenet crown under Godfrey V, Count of Anjou. But it also was a law established and expounded upon and made it sound by the other monarchs, King James. King James upheld this law. King George III upholds this law. All right? King George III was married to Charlotte Mecklenburg, which Queen's College, known as Rutgers University, was named after. Rutgers University was named after Henry Rutgers, who was a slave owner. Okay, and he was named after a university which was allowed to be a university by act of the legislature of New Jersey, which was a violation because New Jersey Constitution of 1947, which was established in Rutgers University, didn't have the authority to do so, because it didn't conform to the original Constitution of the one in Trenton, nor the one that was established prior to that under the province parliamentary law and what we call per Amboy, where our seat of government sits in, because we have convened in quorum under trustees according to Title 16, Chapter 1, Section 28, pursuant to the rights and powers under that charter that goes back to the Parliament of England, that goes back to 1215, which was the government. You have to understand this, it's a government, all right? So we see that the Religion Act of 1580 was already in place before there were even colonies up here in North America, pursuant to the 1606 charter we just read. There were already laws to respect us as English heirs and successors here in what we call England.
Yep.
It must have been England if there's an act passed between subjects of England, and not that it will be treason to break them away from the English Church of England, now called the Church of England, through the House of Tudors, which was passed by the Reformation of the House of Tudors by Queen Elizabeth I. And she is protecting the laws of Parliament that existed prior to her, even House coming on the scene.
Yep.
How we know that? Just look up the Parliament of England, 1215. You see that? Parliament of England was the legislator of the Kingdom of England, not British, not Great Britain, not the United Kingdom. From the 13th to the 17th century, the first English Parliament was established in 1215 with the creation of the Magna Carta. All right? The Magna Carta is the charter rights we stand on by way of incorporation through the Department of Treasury, which is the one who owed the debt by way of the Funding Act and the Registry Act, in lieu of the act we already promulgated in 1790 by way of the census counted Bible settlers who came here to settle and set plantations as known as colonies then, by way of the grant given them by the monarch, known as the king, on behalf of his heirs and successors, who are us, the English heirs and successors, known as the English Third Temple Church, reformed from the English Church of England, which is the English Church we're talking about here within the Kingdom of England. Right here. That's how you have to spit it, y'all. This is how you have to speak. All right. Now let's really go to the root of the source of our problem, brothers and sisters, because Elizabeth I, who allowed the colonies to come over to America, emphasized about violation of the Religion Act by treason, which was treason to let somebody or trick somebody to go against the worshiping of the king or queen or the Church of England. 2 important factors. Keep that in mind. Let's move on, because the basis is Queen Elizabeth I. We're going to show this was a contradictory act on her behalf to make us act such as this and not follow it. And we're going to show you she didn't follow it. Let's get to it. First, let's get to the Constitution, which we left off from. 1776, Declaration of Independence. Main important factors.
New Church Constitution.
All right, everybody can see that?
Yep.
Article 10, the captains and all the inferior officers of the militia should be chosen by companies and the respective counties by the field and general officers by the council and assembly. Now, I got to show you all something. This is our point chart. This is what we use as members of the English Third Temple Church and of the King's Bench. This is what we use to understand our position and status as a people. All right. Now we're reading about Article 10 of July 2nd, 1776 Constitution. Somebody read this first point, because we as a people already understand that all the claims we brought on behalf of us is called subject matter. But the court don't have subject matter jurisdiction if they don't have the law. Understand what law to apply to it.
Exactly.
That's why most of our cases are dismissed, because there's no law to justify your relief you're seeking. All right? And this is a result of your citizenship, which is your subjectivity, political status, and allegiance. Read this, Archbishop.
Point 1. This court is aware of the subject matter concerning the facts of this case, which is that the birth record does not reflect appellant's allegiance, political status, or citizenship as a king, heir, and successors of English ancestry.
Forget all the exhibits.
Certificate of incorporation. What this court need to be aware of is the inherent and equitable authority, standard review of the legislative statutory common law of England, and equitable law of England, governing this colony, termed noun state. This appeal involves the judiciary review of inferior orders, decreed by inferior officers of inferior courts, sanctioned by an authorized legislative body. Dred Scott Sanford was a landmark decision of the United States Supreme Court, in which the court held that the United States Constitution was not meant to include American citizenship for people of African descent, regardless of whether they were enslaved or free. And so the rights and privileges that the Constitution confers upon American citizens could not apply to them. Chief Justice Roger Taney issued what is widely regarded as the worst Supreme Court opinion ever, noted that the question before the court was whether African Americans are citizens of the United States and thus able to file suit in federal court.
Sorry about that. Hold
on. His analysis of that issue was couched in objectively racist language. African Americans had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights, which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold, treated as ordinary article of merchandise, and trafficked, whether a profit could be made by it.
Okay, that's cool. Now let's go back here. All right. So it says in Article 10 of July 2nd, 1776 Constitution.
You got to share it, King.
That reads, oh, 1 second. All right. If I say it?
Yep.
Okay. So we're reading based off Dred Scott case. Now remember, Dred Scott is an unconscious Negro black colored Ethiopian trying to be an American citizen. All right. Supreme Court said you could be an American citizen. Now, I don't know if Dred Scott had a birth certificate, but he was clearly subject to the laws of America based off his status. You know what I'm saying? He had to take allegiance to the state, which made him a subject as a slave.
Mm-hmm.
All right, whether he had a birth certificate or not. So we see in Article 10 that the captains and all inferior officers of the militia should be chosen by companies. So now we first know that under Article, the trustees of the so-called document called the Constitution, which is the first highest class of a form of government, with instructions commissioned by the Crown to the governor. Now, who's the head of the state? The governor. Before you had a governor, you had a royal governor under the laws of the government under Parliament. There is no more Parliament by way of the creation of the state, which broke the laws of Parliament because the Parliament governed the colonies, that governed the United Colonies until they became state by amending the Constitution that we're reading now of 1776 on September 20, 1777 by substituting the word state for colonies, colonies for states. All right. So now the colonies were ran by companies, and by way of substitute the word state for colonies, the states are now companies. Because it said under the original Constitution, where the other two adopted Constitution, 1844 and 1947, were originally created from this original document that don't say nothing about no state. So I mean that according to English National, the first two documents don't even reflect us. You can't even use it. They don't say nothing about the Kingdom of England.
Yep.
We know we got 61-28 rights state under charge of Great Britain. What rights ain't specific? What charges not specific? So we have to make what charter specific we're talking about. The 1606 charter. Okay, yep. And the charter involved colonies and plantations who settled here, and the 13 colonies. And New Jersey was one of the 13 colonies. Actually, the third one, if I'm not mistaken. But you have Massachusetts, Plymouth, New Jersey. He is in there. All right. We ain't going to y'all go do that on your own time. So it says that the captains, now who you report to your local office, police officers, they're called the captains. All right. They're part of the militia. We can't hear you, CA.
Oh, yep. That's the captains.
Okay. And all are inferior. Now, what did Chief of Kennedy said about Black people according to the Constitution that we're reading right now?
They're inferior.
And they can't be citizens of the Constitution, whether they were free or not.
They're not, yep.
Okay, so if they're not free or not, and they were considered according to that order of an inferior order, it didn't say inferior people, it said inferior order. So if you are inferior order, which are inferior people, then you need an inferior court to deal with those inferior orders. Am I right?
Correct.
So that brings in Article 10. The captains and all inferior officers of the militia should be chosen by the companies and respective councils. But the field and general officers, which is the legislative council, which is called the council, and general assembly, called the provincial council. 12, that the judges should continue in the office for 7 years. The judges of inferior courts of common pleas, that's the courts of common law. How we know that? Let's go here.
And the fact that they're saying the judges of the inferior court of common pleas. So everywhere you go in the so-called U.S. jurisdiction, they're court of common pleas, which let you know they're inferior courts.
Inferior courts. All right. Article 2, Article 3, Clause 2, Article 3, Section 2, Clause 1 states, and there's a Constitution of the Federal Union that the judicial power shall extend in all cases in law and equity. So there's only two ways you can hear a matter in a court. You got two jurisdictions. You got civil, for civil law, which is civil, special civil, and criminal. And then in chancery, you got general equity, probate, and what they call probate, general equity, and maternal. I think what's it called? Maternity,
Guardianship.
What you say? Say it again.
Guardianship.
No, it's called. That's heard under what they call probate.
Probate. Okay.
Guardianship. So it's general equity, probate, and it's one more. Probate, and I think it's maternity, something like that. Family matter. No, not family matter. What is it called? It'll come to me. But the main focal point about law is that there are only two: is law and equity. And we know equity is fairness and what's just, which is only be heard in chancery. We know common law, origin of common law is court of exchequer, court of common pleas, and the king's bench. And people who are subject to the laws of the common law, i.e. civil law, file appeals in the courts of chancery to seek remedy that you can't get in the court of law. How we know that? Because the origin of law, all right? But before we even deal with the origin of law, let's deal with the case law to support that America has no common law, all right? Smith versus Alabama.
You got to share that.
I will in a second. Give me a second. Everybody see that?
Yeah, we see it.
Okay. U.S. Supreme Court, Smith versus Alabama, argued January 4th, 1888. Decided January 30th, 1888. Syllabus. Mr. Justice Matthews delivered the judgment of the court, said there is no law, common law of the United States in the sense of a national customary law, distinct from the common law of England as adopted by the several states, each for itself, applied as its local law and subject to such alterations as may be provided by its own statutes. There is, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law in order to be read in light of its history. There is no common law of the United States in the sense of a national customary law, distinct from the common law of England as adopted by the several states, each for itself, applied as a local law and subject to such alterations that may be provided by its own statute. Wheaton versus Peters. A determination in a given case of what the law is may be different in a court of the United States from what which prevails in the judicial tribunal of a particular state. This arises from the circumstances that the courts of the United States, in cases within their jurisdiction, where they are called upon to administer the law of the state in which they sit or by which the transaction is governed, exercises independent though concurrent jurisdiction and are required to ascertain and declare the law according to their own judgment. All right. So as you can see here under Smith versus Alabama, that the United States has no common law of its own other than that of the common law of England. And as we read that in the Constitution, we're reading now. This is the common law of England. How we know that? Article 22. Everybody see that?
Hasn't came up yet. Share it. Got to try to share it again.
I'm sorry.
All right, Article 22.
Yes.
All right, says that the common law of England, as well as so much of the statute law as have been heretofore practiced in this colony, should still remain in force until they shall be altered by a future law of the legislator, such parts only accepted as are repugnant to the rights and privileges contained in this charter, and that the inestimable right of trial by jury shall remain confirmed as part of the law of this colony without repeal forever.
So as you can see, under the common law of England, as Smith versus Alabama said, that the law of the common law of New Jersey is the common law of England, as it states right in the statute specifically. And it should remain hereforth in effect until altered by the state legislature, as it did in the 16-1-28, right? Seen under the charter of Great Britain, because the Constitution is a charter.
Yeah.
It's the highest form of charter, first class, issued by a monarch to the governor, commission with orders attached. These are orders.
Mm-hmm.
All right. So, and it says in Article 22, in lieu of the enforcement of the English law of the colonies, it said that they can only set things that are repugnant to this charter. That's why they had to amend it in September 20th, 1777, because it does not include them as a state. And this is why they always include what they call a catch clause, or what they call escape clause. It's called nullification, certification, provision, and escape clause. What is the escape clause for this contract in regards to the grantor and the grantees, which was the king, the heirs and successors, and the grantee, the settlers or the colonists, on behalf of the heirs and successors, and who are we? Who are us? So we are the successors or the beneficiaries of the yielding that was done on behalf of the colonies and plantations that were given to them by a grant by the monarch, by de facto monarch, sitting on the government, on the parliament that we represent in the House, which was convened and took them back under Title 60, Chapter 1, Section 4, pursuant to Title 60, Chapter 1, 43.8 and 9, which is the rights that under the charters that were in those previous corporations were convened by way of trustees, and the only way it can be conferred in lieu of the legacy was by way of a decease. And we know that there is no decease, so we have to make a claim by way of King Perin Patriarch, which we're going to see in another court case that we have here to validate our argument, which is Pennsylvania Baptist Association versus Hart's Executor, which was a charitable act or charitable association set up under the Charitable Act set up by Elizabeth I, the one who usurped our state. And by way of the Election Act of 1580, it clearly showed you that what she established here as the companies under the offices of King James was not for to be given to heirs by way of substitution. It was supposed to be passed to us by way of operation of law, but that didn't happen as a result of the state intoxicated with what we call sovereignty, drunken on what we call sovereignty, when the colonies didn't even exercise that type of drunkenness on sovereignty. Come on, y'all better hear me. All right. So here's the escape clause or the notification provision that's on the New Jersey website. It's on the state of New Jersey website, this charter right here, and shows that there's treason, because why would you have this contract that doesn't mention anything about the state? How we know that? It says here in the escape clause or the notification, clarification, certification provision, it said provided always, and that the true intent, meaning of this Congress, that if there's a reconciliation between Great Britain and these colonies should take place, and that the latter be taken again under the protection of government, i.e. the colonies of the Crown of Great Britain, this charter should be null and void, otherwise to remain firm and viable. How we know there's a reconciliation? 61-28. How we know there's a reconciliation? Because of this escape clause. That's how we know. But there needs to be heirs in lieu of the deceased estate that has succeeded to the state, and there is no state to take the place of the contracting parties, who are us, the heirs and successors, and the colonies who no longer exist. You can't tell me I ain't no king. You cannot tell me that. Okay? So let's show you the treason that was done and the Religion Act that Elizabeth I stated they honored, King George III said he honored, as well as King James I, the one we're reading about, who was soon to be the first king of England, and he was not. Why? Because he was the sixth king of Scotland. And according to the Alien Act of 1705, he violated the law again. I'm telling you, bro, I'm bad. I'm back. But let's move forward. It says on September 20th, 1777, the legislature of New Jersey, now mindful of what was done in Dartmouth versus College, as well as what was done by Henry Rutgers when they changed Queens College into Rutgers University by way of a legislative act of New Jersey, the same act that was done in this legislative by changing the colonies to states. The colonies to states. And we know that Queens College, now known as Rutgers University, was actually chartered by a royal governor named William Franklin, the illegitimate son of Benjamin Franklin, who was a loyalist, not a patriot. Okay, so it says the New Jersey legislature amended the Constitution, the one we're reading right now, on September 27, September 20, 1777, to substitute the word states for states and colony for colonies. That's a violation and a violation of contract law. You cannot do it. They got it off because there wasn't no heirs and successors, and the damn sure wasn't no king. Yep. Why? Because you look on the census chart right now and you don't see us there. Why? Because we were not the one supposed to be taxed. We were not supposed to be on that census chart as we qualified in the opening of this first video in regards to the origin of where census come from, which denotes the poll tax on foreigners. Now let's show you who these foreigners really are. Let's get there. Bill of Rights. What's our time look like?
Still got like a good 10 minutes.
All right, go ahead and read CA.
Bill of Rights 1689. The Bill of Rights 1689, also known as the Bill of Rights 1688, is the landmark act in constitutional law of England that sets certain basic civil rights and clarification to who be next to inherit the crown. It has received the royal assent on 16th December 1689 and is reinstatement in statutory form of the Declaration of Rights presented William of Orange. Let's see here. A Declaration of Rights presented by the Convention, Parliament, William III and Mary II in February 1689, inviting them to become joint sovereigns of England.
Stop right there. Okay. So the Bill of Rights of 1689. Now, America got their own Bill of Rights, but it comes from this Bill of Rights on who was successor, who would inherit the succession of the crown. And when you get into that, the crown estates, because we know that the colonies are crown estates because they're subject to the monarch. So when you're dealing with these crown estates, but it said under the Parliament of England. So these are trustees under England, constitutional law of England, certain basic civil rights, and clarifies who would be next to inherit the crown. All right, so this crown happened to be the Commonwealth that they set up. All right, overseas possessions. We ain't gonna get into that, but we want to go into the reason why they set up the Bill of Rights of 1688. All right, let's go here. Now, William III and Mary II were monarchs of the House of Stuart, and they the one who the colonial college, William Mary Orange College was set up, where all the Native Americans identified now were actually re-educated and taught the history of foreigner identified as Nickelback on the Ethiopian, and then they took on the identity of who you are as Englishmen. All right, so this is a Bill of Rights in lieu of who would inherit the crown, and this goes into what we call the ruling monarchs who were not Roman Catholic but Protestants, known as Anglicans, Presbyterians, Methodists, Calvinists, Lutherans. All these were those who were set up as colonies here. Massachusetts on down. Okay, so let's bring us to what we call the Travel Usage Act. As we said again, the Travel Usage Act of 1601 was the act of Parliament of England. We said Parliament of England was established in 1215. That's our house. That's the government. But a charitable act passed by a parliament as the House of Stewards was de facto, and we're going to show you why. Because they were not the citizens of England. Let's get there. Where is that? Act of Settlement. No, not that one. Act of Settlement on 1. Where is it at?
I think that's it right there about the Act of Security, Act of Settlement on 1.
Right there, I'll go ahead. Right above it?
Oh, yeah.
Okay, yeah. Look at who the party is at, y'all. Now, we already established in the Bill of Rights of 1689 who would inherit the crown. And it's based off those religious institutions because we know the Church of England was the ones who was under the authority of acting under the authority of the crown as the minor. So the Bill of Rights of 1689 was the one who would inherit the crown of the successor colonies who were coming over here to be ruled under a monarch placed there, and not the true monarch by way of agnatic succession, which was a result of what was done through the Edwardian wars under Edward III and his son John Gaunt. All right. So it says that you can go on and read Archbishop Act of Settlement.
Okay. The Act of Settlement, 1781. The Act of Settlement is an act of Parliament of England that was passed in 1701 to settle the succession to the English crown, succession of the Irish, to settle the succession to the English and Irish crowns on Protestants only.
Stop. Okay. So now this is the Act of Settlement, talking about the Bill of Rights, because the Bill of Rights was about who would the crown succeed to, right?
Right.
So now they went in full detail in lieu of the Act of Settlement. Once they settle here, who the crown would go to. And it said who? The Protestants.
Protestants.
But they're not heirs and successors or descendants of the English or Irish crowns. So how can an act that was created under the auspices of Act of Parliament of England that should go back to 1215, but it didn't. It started in 1701 with a de facto Act of Parliament of Scotland, which was not supposed to be done because King James forced them to do this. Yes. All right, by way of what we call the Act of Union and the Treaty of Union of 1707. All right, but this was based upon the Protestants, as we said, were many branches: Methodist, Lutheran, Calvinism, Anglican. All these faiths originated from that. Okay, on behalf, like I said, the Protestant, on the English and Irish crowns. This, go ahead, finish reading.
It said this had the effect of deposing the descendants of Charles I, other than his Protestant granddaughter, Princess, later Queen Anne. As the next Protestant in line to the throne was the Electress Sophia of Hanover, a granddaughter of James VI and I. After her, the crowns will be only descend to her non-Catholic heirs. The Act of Supremacy 1558 had confirmed the Church of England's independence from Roman Catholicism under the English monarch.
Stop. Okay. So as we know, as we're dealing with the Act of Settlement of who would inherit the crown of the English and Irish monarchs, and it only will pass to Protestants and not Roman Catholics, by way of those who descended from King James, by way of him would be related to Sophia of Hanover, whose son was King George III. So this act was in 1701, and they're already premeditated to carry this act on in 1714 when Queen Anne passed to who? King George III. Y'all got to be scratching your head for it to be right here in your face. They're already predetermined that who was going to succeed the crown way back in 1701, but it didn't happen until 1714. 13 years later.
Your last.
All right, y'all got to follow our timeline. How we know that? Because the Act of Supremacy, which was by Elizabeth I, was a reformation of the Act of Supremacy of King Henry VIII in 1534. Let's make sure. I know what I'm talking about. Let's make sure. Act of Supremacy Act. The Act of Supremacy Act by Elizabeth I, sometimes referred to the Act of Supremacy of 1559, is an act of Parliament of England passed under the auspices of Elizabeth I. It replaced the original Supremacy Act of 1534, issued by Elizabeth's father, Henry VIII. Okay? So I know what we're talking about. All right? And we said Elizabeth passed what? The Religion Act of what? 1580?
Yep.
And what did the act say, Archbishop?
Says that it would be high treason to try to get the English subjects to move their allegiance from the king or the queen of England and the Church of England to Rome or a foreign authority. Okay,
he just put that to y'all, but let's read it for yourself. The Religion Act of 1580 was an act that Parliament of England during the English Reformation, and the English Reformation was done by who? The House of Tudors, under Queen Henry VIII and Elizabeth I. But yet they passed this act to make them foreigners to not be able to inherit the estate that belongs to the beneficiaries, who are us, but it is stated because they enslaved us again.
Yep.
All right, let's get to it. All right, so this was the act of 1580, and we're gonna go back to the Settlement Act of 1701. What is it, 1701, which is the act right here, in lieu of the settlement only on Protestants. All right. So now, since this was happening, they already put their plan in action, and we know it's a plan that was in action because it didn't come to fruition till 1714 when Queen Anne passed it to George III, because they admitted it right here. King Charles I, who was beheaded as the next other than his Protestant granddaughter, Princess Lady Queen Anne, as the next Protestant in line to the throne, which was Elector Sophia of Hanover and granddaughter of James VI in the first. She was a Calvinist. She practiced Calvinism, which was another part of the Protestant church. All right, let's move further. So now, since we got the Settlement Act, that brings us to what we call the Security Act of 1704. I hope y'all writing this down, brothers and sisters. How much time would our time look like?
We got like 5 minutes left.
Okay, it's enough for me to do that. Where is it at? Oh. Act of security. What did I do with it? Let's try here. Here we go. 1604. Religion Act, that's not it. Let's see. Where is this at? Y'all give me a second. Let me just find it. I'm gonna have to look up again. Active security. Yeah, let me look it up. I thought I had it, but apparently not. Oh, there we go. Y'all see this? Okay,
Yes.
active security. Read, Archbishop.
The Act of Security 1704 was a response by the Parliament of Scotland to the Parliament of England's Act of Settlement 1701. Queen Anne's last surviving child, William, Duke of Gloucester, had died in 1700, and both parliaments needed to find a Protestant successor. The English Parliament had settled on Elector Sophia of Hanover, granddaughter of King James VI I, without consulting the Scottish Parliament.
Stop. You hear that? Without consulting our Parliament. Now, they already had the Act of Settlement of 1701 that would pass Sophia. But now this Act of 1704 came about that Parliament of Scotland didn't even agree to, even though King James was a monarch. They didn't agree to it, all right? And it said what?
It said the response to the Scottish Parliament was to pass a bill in 1703 requiring that on the death of Queen Anne without issue, the 3 estates of the Parliament were to appoint a Protestant successor from the descendants of the Scottish kings, but not the English successor, unless various economic, political, and religious conditions were met.
Read that again.
It says, the response of the Scottish Parliament was to pass a bill in 1703, requiring that on the death of Queen Anne without issue, the 3 estates of the Parliament were to appoint a Protestant successor from the descendants of the Scottish kings, but not the English successor, unless various economic, political, and religious conditions were met.
Stop. Okay. So under this Act of 1704 Security Act, they passed an act for that it can pass to Sophia handover if there was no problem, and that it would not pass to an English successor, which according to the Parliament, it's supposed to pass to an English successor. But they didn't. Because we know their true intention on this act was based off the Settlement Act of 1701 to pass it to a Protestant, such as King George III, which he did in 1714. But the Treasury Security Act of 1704 said that the States Department was to be appointed to a Protestant successor from the descendant of the Scottish king, but not the English successors, unless a certain requirement was met. That requirement was incorporation, because it said economic, political, and religious conditions were met. That's called citizenship, political status, allegiance, and subjectivity of the king, which brings economics to you. All right? Pretty mom, we look beautiful. Okay. So we know that based off this act of security in 1704, they deliberately tried to deny us our birthright in lieu of our citizenship here on these territories, now known as colonies, now known as states, to Scottish kings. All right? To Scottish kings, and unless our economic, political, and religious conditions were met by the English heirs and successors. And they tried to stop this from happening. Now look what our ancestors did again to protect this estate that belongs to us. They came with the Act of 1705. Alien Act of 1705. Somebody read that.
All right, Alien Act 1705.
The Alien Act.
Go ahead, CA.
The Alien Act was passed by Parliament of England in February 1705 as a response to Parliament of Scotland's Act of Security in 1704. Partially a response to the English Act of Settlement 1701.
Stop. Now this one paragraph says a whole lot. They said the Alien Act that was passed by the Parliament of England, which is our house, 1215, House of Lords and House of Commons, passed a law by the Parliament of England on February 1705 in response to the Parliament of Scotland of the Security Act of 1704. They said that it's supposed to be passed into a Protestant unless the English met certain conditions on the economic, religious, and what was the other term they said? Political. Or something like that.
Yep, economic, religious, and political.
Political. As long as we met these requirements. So our answers, the Parliament of England, our government, countered it by passing the Alien Act of 1705 as a result of the Security Act of 1704 on the auspice of the Settlement Act of 1701. Because in 1701, they already knew what they were going to do with the Security Act of 1704 and the transfer of our state in 1714 to a Protestant known as Sophia Handover's son, King George III. All right. And he agreed on the Religion Act that it will be treason to allow somebody of an English successor who worshiped the king or queen of England or the Church of England to worship a foreign state, such as the House of Handover, the House of Stuart, the House of Saxon-Coburg, and the House of Windsor, because they were not the kings and minors of the Kingdom of England. Because why? The Kingdom of England passed its Alien Act. And read what else it says.
Alien, let's see here. Lord Goblin,
Beautiful.
the Lord High Treasurer, was instrumental in the Union of 1707.
Sit down.
So, Union of 1707
Sit down, pumpkin.
and all the acts leading up to it, the Alien Act passed the
You're breaking up, CA. Is he breaking up, Archbishop? Sound like he's breaking up.
No, I'm not breaking up, but CA, you kind of breaking up.
Oh, I'm being flow. Let's see. Lord Gaplin, Lord High Treasurer, was instrumental in the Union of 1707.
Yes.
And leading up to it, the Alien Act was passed to prevent inconveniences that would occur hastily if these two kingdoms become
They're breaking up.
still breaking up.
Yeah.
It's still breaking up.
Try to start over again with the act.
Okay. The Alien Act was a law passed by Parliament of England in February 1705 as a response to the Parliament of Scotland's Act of Security in 1704, which in turn was partially a response to England's Act of Settlement of 1701. Lord Godwin, Lord High Treasurer, was instrumental in the Union of 1707 and all acts leading up to it. The Alien Act was passed to prevent the inconveniences that would occur hastily if these two kingdoms were not to become one union. The Alien Act provided that Scottish nationals in England were to be treated as aliens, foreign nationals, and the estates held by Scots would be treated as alien property, making inheritance much less certain. It also included an embargo on imports of Scottish products into England and English colonies, about half the Scottish trade, covering goods such as linen, cannel, and coal. There was also an embargo on export of arms, ammunition, and horses to Scotland so that they could not raise an army to invade England. Faced with an economic pressure, that Scots decided to unionize, something that certain interests in England had wanted to over a century. With the Union of 1707, free trade was established along with single parliament.
Okay, that's fine. So as you can see with the Alien Act, our ancestors countered the Security Act of 1704 as a result of the Settlement Act of 1701. In lieu of setting up Protestant community and a Protestant monarch that broke away from the Roman Catholic Church under the de facto monarch that descended from Charles I, who got their daughters from the House of Tudors as a result of the usurpation of our state through the House of what we call the House of Stuart, which was under the auspices of the House of Tudors under Elizabeth I, when they clearly stated in the Religion Act of 1580 that they were not supposed to do that.
Mm-hmm.
All right, this was the direct violation of birthright. This is protected under Calvin's case. All right, let's go here.
All right, that was our 30 minutes for this, for part 4.
Okay, so we're gonna close out, and we're gonna come back with part 5 of have you registered under the English registry as a citizen of English birthright. Once again, we'll get that title right in a second. But we'll see you in the field. Peace.
Peace.